Alors, je propose qu'on commence notre réunion.
Okay, I suggest we get started with our meeting. I think everything's working, technically speaking. Thank you. So, item 1 of our agenda, adoption of the draft agenda. If there are no objections, then we'll consider that adopted. Item 2, Chair's announcements. As usual, our meeting is being web streamed live. Interpretation is taking place in English, French, German, Italian, Portuguese, Swedish, Hungarian, Polish and Romanian. And also in Turkish, just for the item on Turkey. The interpreters rely on the quality of your interventions in terms of sound quality, but also in terms of visual quality. So if you're connecting remotely, please use your cameras, otherwise you will not be interpreted. Pursuant to the President's decision, there is a requirement to wear a mask in the building at all times, but that doesn't apply to a person chairing a meeting, and obviously you'll be able to take your mask off when you're speaking. I have the great pleasure, by beginning this meeting, by giving you some excellent news. The Supreme Court of Saudi Arabia has annulled the death sentence of Abdullah al-Awiti, which had been decreed when he was 14 years old. He was held in secret and tortured until he confessed to a crime that he hadn't committed. There was a European Parliament resolution in June 2021. We called for him not to be executed, and we called for his confession under torture be withdrawn, and that the torture that he was subject to be subject to an investigation. So this is a signal that we welcome, and we hope that other signals, particularly relating to the death penalty, will follow in Saudi Arabia. Item 3 now. Exchange of views on the state of Turkey's judicial system and respect for fundamental rights in law and in practice. So this opens our meeting on the situation with regard to fundamental rights in Turkey and the latest developments. I'm going to wait for Bernard to finish playing with the settings on his phone. Take your time, Bernard. Okay, great. So, the signals that we're receiving from Turkey are alarming in terms of human rights. Our Parliament regularly, obviously, expresses itself to denounce the systematic harassment and muzzling and arbitrary detention which is taking place against the critics of the Erdogan regime. The Parliament has opened its doors several times to civil society actors and to the victims of this authoritarianism. Obviously, that doesn't just relate to Turkey. This is a principle that we have in this committee. We give the floor to people who don't have the right to speak in their country of origin. Everyone is affected here: journalists, artists, writers, lawyers, political representatives of the opposition, etc., etc. Now, the worst attitude would be for us to be silent, for whatever reason that may be. When a country is a member of the Council of Europe and accepts that the decisions of the European Court of Human Rights be applied in its territory, and when its leaders say that they want to join the European Union and share its values, it's crucial for us to hold dialogue to ensure that these don't simply remain statements and also relate to the actual application of these values. This morning I had the opportunity to meet the Turkish ambassador to the European Union. We discussed these matters, and I hope that the dialogue that we undertake today will enable us to go on a mission to Turkey, which will enable us to gain more information on the situation with regard to human rights. Now, without further ado, let me give the floor to our guests. They're experts on the situation with regard to human rights. Philippe Dam, Director of Human Rights Watch at their advocacy department. He replaced our first guest, Mark Pierini, at the last minute. Then we have Mrs. Rehsan Bataray, Saman, lawyer and vice chair of the Human Rights Association in Turkey. Then we have Luca Perilli, judge, a former EU independent expert on accession countries in the context of the rule of law, and a former expert for the Council of Europe on Turkey. And then finally we'll have Mr. Johan Vande Lanotte, senior legal counsel and former state minister of Belgium. So let me give the floor to Philippe Dam for 10 minutes. You have the floor, please.
Merci, Madame la Présidente. J'espère que la connexion est bonne.
Thank you, Madam Chair. I hope you can hear me. I hope it's a good connection. I'd like to thank the committee for your interest in the situation in Turkey. The speaker now switches to English.
And highly centralized presidential administration in the country has really set back Turkey's human rights record by decades. Perceived government critics and political opponents are systematically targeted. Political influence over the judiciary has led courts to systematically accept bogus indictments, detaining and convicting individuals of groups perceived as critics, and among them, of course, journalists, opposition politicians, activists, lawyers, and human rights defenders, despite the lack of evidence of criminal activity. In March this year, as you know, Turkey was the first country to withdraw from the Istanbul Convention, offering a major setback to women's rights in the country. Since a key focus of this exchange of view is about the state of Turkey's judicial system, I would like to remind the truly grotesque nature of the arbitrary detention and continued trial of Osman Kavala, a leading figure of Turkey's civil society, which exemplifies for us the enormous pressure on human rights groups and other human rights organizations in the country by the way of the country's flawed judiciary. As you know, Kavala is on trial on baseless charges of connections with the 2013 Gezi Park protest and the 2016 failed coup attempt. The European Court for Human Rights ruled already 2 years ago that by holding Kavala in pretrial detention since November 2017, and by prosecuting him on the basis of his human rights activities, the Turkish authorities had pursued, and I quote, an ulterior purpose, namely to silence him as a human rights defender. A Turkish court once again in October this year failed to release Kavala. This Parliament and this subcommission should push for the importance of the implementation of ECHR's judgment and should remind that Turkey will be notified by the Council of Europe's Committee of Ministers of infringement proceeding at its upcoming November 30th session if Mr. Kavala is not released from prison by then. Similarly, the European Court ruled on December 22 last year that by holding Selahattin Demirtas in pretrial detention since 2016 and by prosecuting him for activities and speeches protected under the European Convention, the Turkish authorities are preventing him from carrying out his political activities and also called for his immediate release. The authorities, in fact, continue to use terrorism and defamation charges to harass human rights defenders. The Court of Cassation has yet to review the 2020 convictions for membership of a terrorist organization and aiding and abetting terrorism of Mr. Taner Kilic, the former chair of Amnesty International Turkey, and 3 other individuals. The conviction in February of Eren Keskin, the co-chair of the Human Rights Association, and the brief detention and continued investigation on her other co-chair, as well as the conviction of 2 activists running the Diyarbakir-based Rosa Women's Association, do demonstrate the continued use of courts to silence independent civil society. And this year, the ruling coalition has intensified an ongoing campaign to criminalize the legitimate political activities of opposition People's Democratic Party, the HDP, deliberately refusing to distinguish between the HDP and the PKK. Scores of former HDP politicians, including elected mayors, are held as remand prisoners or are serving sentences after being convicted of terrorism offences on the basis of their legitimate, not violent political activities, their speeches, or their posts on social media. The show trial that began in May this year against dozens of current and former HDP politicians is one illustration of this reality. And in June, the Constitutional Court accepted an indictment filed by the Court of Cassation's chief prosecutor to permanently shut down the HDP and impose a 5-year ban from any political activity to 451 politicians and party officials. This case is ongoing. There was little evidence to suggest that prosecutors have made progresses in investigating the rising allegations of torture and in treatment in police custody and prison, which was reported over the past 5 years. As far as freedom of expression is concerned, there are just under 60 journalists and media professionals who are still currently in prison or serving sentences for terrorism offences because of their journalistic work or association with the media. Most news outlets in the country are now owned by companies which have close links to the government, while independent media in Turkey, which continue to operate via online platforms, continue to be subject to regular removals of content or prosecution for their critical news coverage. The government, in fact, recently signaled the plans to further tighten restrictions on social media by making so-called disinformation via social media an offence which would be punishable by 2 to 5 years of prison. Thousands of people, in fact, already face arrest and prosecution simply for their social media posts, typically charged with defamation, insulting the president, or spreading terrorist propaganda. And in fact, major social media platforms such as YouTube, Facebook, or Twitter have decided this year to comply with the 2020 legal amendment, which requires them to set up an office in Turkey. And this raises serious concerns that they may in the future be forced to increase their compliance with the governmental censorship. And finally, we have to flag that the government has banned once again the annual LGBT Pride in Istanbul. This is for the 7th consecutive year, and police this year again dispersed and detained protesters. And to conclude, I would like to make a few recommendations to this subcommittee and to the European Parliament. First of all, we call on you to press Turkey to effectively and immediately implement in full the European Court's rulings concerning Osman Kavala and Selahattin Demirtas, immediately release both men and address the systematic problems in Turkey's justice system. This subcommittee should also support the use of infringement proceedings by the Committee of Ministers of the Council of Europe if Kavala is not released by its next meeting. We also call upon you to call Turkey to reverse the withdrawal from the Istanbul Convention, and also press Turkey in the meantime to prevent and combat domestic violence against women and girls, support survivors, and hold abusers into account, and in this way to fully implement Turkey's own legislation number 6284. Finally, we would like to encourage you to call on the Council, the Commission and the HRVP to make it clear that the deterioration of the human rights situation in Turkey will hamper the positive EU-Turkey's positive agenda proposed by the European Council, and to clarify that the talks on the modernization of the customs union called on by Ankara should not begin until concrete and measurable progresses are taken to improve the independence of the judiciary and the accountability of institutions in the country. I thank you for your attention and remain ready to respond to questions or comments by members of this committee.
Thank you, Philippe. I give now the floor to Rehsan Bataray Saman. You have the floor. Saman.
Merhaba, saygıdeğer katılımcılar. Hello, I am representing the Human Rights Association of Turkey. I'm co-chair of Human Rights Association in Turkey, which was established in 1986. It's a well-established civil society organization. Together with the state of emergency, which was announced in the aftermath of the failed coup, we are facing with some grave violations, especially against the Kurdish community, especially those activists, human rights defenders, Kurdish human rights defenders and politicians are either restricted or investigated or even detained. So the judiciary is instrumental in this oppressive policy emanating mainly from the anti-terror law. Osman Kavala, Selahattin Demirtas, unfortunately, are detained under anti-terror law. Many human rights activists are also detained pending trial, and they are some are sentenced again under this same law, anti-terror law. Before 2015, as you know, we had the peace process. There were negotiations between the PKK and the state of the Republic of Turkey, and politicians were rather free to state their opinions regarding the Kurdish issue. So it's been around 6 years, and since 2015, those social media posts of human rights activists that were posted 6 years ago, they are being investigated today. I will give you examples from 3 case files. Malatya president, chairperson of Human Rights Association, Diyarbakır and Ağrı chairpersons of the Human Rights Association are being tried these days, and they unfortunately have been sentenced, convicted, because of their declarations, speeches they made on behalf of the Human Rights Association. So many other people are being tried similarly. Human rights defenders, human rights activists, press members, journalists, lawyers are being oppressed, and there's impunity for quite some time, especially in the southeastern part of Turkey, for grave violations of human rights. And some documents, international documents, describe these violations as crimes against humanity. We see impunity still prevails. And unfortunately, impunity is the main reason why we see so many violations, because states officials unfortunately are very confident that they would not be sanctioned because of the violations they have committed. As you know, forced disappearances while under detention was rather seen in 1990s, and many case files have either been suspended or closed or decided non-lieu. And as a result of some great efforts by lawyers, some case files were brought again before courts, but many of the perpetrators were just acquitted. For example, many army officials were tried for cases of disappearances in 1990s, and these cases have also been brought before the European Court, Strasbourg Court, and unfortunately, despite the European Court of Human Rights ruled violation, these people, perpetrators, were acquitted in Turkey. And in some other cases, again, non-jurisdiction was ruled by Turkish courts. So impunity, as I said, is still prevailing in Turkey, and oppressions and threats experienced by lawyers, by activists, human rights defenders. Kulp case file or Roboski case file, for example, are some examples to impunity. The then Diyarbakır Bar Association President Tahir Elçi, a human rights activist, a peace activist, unfortunately he was assassinated, and the investigation file for his massacre didn't yield any proceedings, and impunity still prevails. On the 28th of October, we commemorated his 6th anniversary, death anniversary. The judiciary and human rights violations and the situation in prisons, because the system has become much more authoritarian, and the prison population increased in Turkey as a result, and their arbitrary treatment in prisons and oppression, also many violations, and there is a significant increase in complaints, especially detention of gravely ill prisoners is a very important problem. 604 prisoners are gravely ill, and more than 1,600 sick prisoners are currently detained in prisons. Hamili Yıldırım and Ömer Ali cannot, for example, communicate with their lawyers, and for quite some time they don't have access to their lawyers. So Turkey is violating not only international documents but also its own criminal procedure code and criminal code. As human rights activists and advocates for human rights, we prepare regular reports as the Human Rights Association of Turkey. I don't want to take much of your time. That is why I don't want to go into too much detail. You can access these details on our website. And I would like to draw your attention to the situation of refugees, thousands of refugees at the border of Belarus, Russia, and Poland. We got already in touch with international organizations and also with some ambassadors. We would like to draw the committee's attention also to the situation of refugees at the border of the two countries. We are advocates of human rights, and we shall continue to defend human rights. Human Rights Association also fights against wrongful policies which lead to violation of human rights. And while doing so, it's very important for us to be able to participate in this meeting. And it's also very important for us to see you deciding as a committee to that effect. Thank you very much.
Thank you very much. And now I'll give the floor to Luca Perilli. You have the floor for 10 minutes, Luca.
Good afternoon. Many thanks, Ms. Arena, for the invitation. I guess there should be a slide presentation that I don't see. Okay, the presentation is here. Thank you very much. So I acted as independent expert of the European Union in Turkey since 2008 until 2015 in the context of the negotiation for the accession of Turkey to the European Union in relation to Chapter 23, Rule of Law. I also drafted official reports that have been published both by the delegation of the European Union and the Ministry of Justice. In 2015, the mission to Turkey was suspended by the EU because of the deterioration of the political environment, and I stopped visiting Turkey. This year, I drafted a new report about rule of law in Turkey, for a tribunal set up by the European civil society, the Turkey Tribunal, that held its session in September in Geneva, and the session had been closed by a verdict issued by an international jury that has found gross violation of fundamental rights by Turkey in the context of rule of law. The report is public and includes many sources of information. I would like only to highlight the fact that it has been endorsed by the European Association of Judges and by MEDEL, that represent many thousands of European judges and prosecutors. I would try now to depict the situation of rule of law in Turkey according to my point of view. On 12 December 1999, when it was recognized as a candidate for full membership to the European Union, Turkey embraced the way of the reforms to reinforce rule of law and the protection of fundamental rights. Next, please. Year 2010 marks a very positive landing of this wave of judicial reforms, because Turkey adopted constitutional amendments to the constitution that reinforce the independence of the judiciary and therefore the protection of fundamental rights. First of all, Article 145 of the Constitution introduced this remedy, a remedy in front of the Constitutional Court, that became operational by 23 September 2012 and proved to be very effective in the first 4 years of its implementation. I can mention here without further elaboration, because of time constraints, the Twitter ban case when Twitter was closed by the government and reopened by the court in 2014, or the case of Mustafa Balbai, who was an important writer and journalist that was detained and released by the Constitutional Court, or Can Dündar, who is an important columnist and writer, and nowadays refugee in Germany, that as well was released thanks to a decision of the Constitutional Court. The second important change regarded the High Judicial Council, that was made pluralistic and representative of the Turkey judiciary as a whole. And this eased the hierarchical structure of the Turkey judiciary and started to protect the judicial independence against threats from without and within the judiciary, and to create a safe environment for independent actions of judges and prosecutors. Next, please. According to my consideration, it is year 2013 and not 2016, the year of the failed coup d'etat, that marks the decisive turning point for the rapid decline of the rule of law and the protection of fundamental rights in Turkey. On 28 May 2013, a wave of civil demonstration began in Istanbul, as everyone remembers, to protest against the urban development of Taksim Gezi Park. Peaceful demonstration lasted for almost 20 days, involved more than 2.5 million people, and they were violently repressed by the government. And at the core of the protest, there were the fundamental freedoms of a democratic society, such as freedom of the press, expression, and assembly. The second important event happened at the end of 2013, beginning of December, when the police, coordinated by independent prosecutors, arrested sons of 3 cabinet ministers and at least other 34 people, including leading businessmen, and that were said to be engaged in suspected corruption, bribery, and tender rigging. Their reaction, the next please, the reaction by the government, the political majority, was immediate and harsh. The independence of the Council of Judges and Prosecutors were curtailed by an omnibus law adopted in February 2014 that dramatically increased the control of the government over the Judicial Council. This law would have been later declared unconstitutional by the Constitutional Court. And between 2014 and 2016, the political control High Judicial Council engaged in large-scale transfer of judges and prosecutors without their consent, and also some judges and prosecutors were arrested because they were dealing with sensitive cases, and investigations were disliked by the government. Therefore, transfer and detention of judges and prosecutors who perform investigation or adopted decisions disliked by the government happened much before the attempted coup d'etat. Here, 2013 signed the descent toward the dissolution of rule of law. The 15th July, next please, failed coup d'etat instead was an invaluable occasion for de-escalation in the attack by the government to the rule of law in Turkey that was rooted in the state of emergency that would have lasted for 2 very long years. During those 2 years, almost 4,400 judges and prosecutors were dismissed. More than 1,600 judges and prosecutors were arrested only in the aftermath of the failed coup d'etat. The rest, symbolically, hit first to judges of the Constitutional Court, Arslan Altan on the left in the slide, and Erdal Terkan, who were taken into custody the following day, 16th of July, because the Constitutional Court had been the shelter of fundamental rights in the previous years. Arrest also caught 5 members of the Council, 140 members of the Supreme Court, 40 members of the State Council. The Association of Judges and Prosecutors were dissolved by the emergency decree, together with further 1,400 associations active in various fields of protection of fundamental rights. Murat Arslan, on the right in the slide, president of the independent and secular Turkish Judges Association Uyarsav, was arrested and convicted to 10 years of detention, and later he was awarded the Václav Havel Human Rights Prize whilst in detention by the Council of Europe. Next, please. As it was said before, the human rights defender paid a very high price, being target of the arrest and detention, hundreds of lawyers detained and prosecuted, and as well representative of NGOs, such as Taner Kilic, already mentioned, which is on the right in the slides. There were also allegations of ill-treatment and torture during detention. Some judges and prosecutors died in prison, and the same happened to lawyers, as in the case of Ebru Timkit on the left, who died in July 2020 after 230 days into a hunger strike in Silivri prison, demanding a fair trial. The judiciary and the human rights defender were prostrated by arrests and dismissal. Fear produced a chilling effect among those who had not been arrested. And in this climate, the rule of law in Turkey definitely sank. The next, please. The 2 final steps toward the political control of the judiciary were a 2017 constitutional amendment confirmed by a controversial referendum that put the High Judicial Council under formal political control, and the recruitment of more than 10,000 new judges and prosecutors in few years, after the dismissal of 4,400, following procedures that have been evaluated not transparent and politically affected by independent observers. Next, please. In conclusion, judicial independence has been progressively demolished in Turkey, starting from 2013 with a dramatic acceleration after July 2016 under every profile. External independence, internal independence in its 4 features, individual independence from internal and external pressure, individual independence from internal hierarchies, the principle of natural judge, the free rights of association, the appearance of impartiality, the autonomy and independence of the Council of Judges and Prosecutors. Next, please. The consequence of the dissolution of the rule of law are made evident by the misuse of pretrial detention already mentioned by the previous speakers largely, and by the clear fact that the first decision issued by the Court of Human Rights in landmark cases, such as those of Arslan Altan, former Deputy President of the Constitutional Court, or the philanthropist Osman Kavala, already mentioned more than once on the right in the slide, and the former co-chair of the HP, the pro-Kurdish party Selahattin Demirtas, on the left in the slide, are disregarded and not enforced by Turkey in clear violation of its international obligation. Thank you for your attention.
Grazie mille, Luca. Now I give the floor to Johan Vande Lanotte.
Thank you very much, Mrs. President. I will try to explain a bit the Turkish Tribunal, how it was created and what were the findings of that tribunal. Can you put the slides, please? First of all, the origin, why we started this initiative. I have it on the slides. Three causes. First of all, the increasing number of allegations of violations of human rights, torture, abductions, press freedom, arbitrary detention. No Turkish national independent judiciary to correct. And thirdly, the normal international mechanisms like the European Court, like the UN Committee, the European Committee for Human Rights, the Special Committee for Enforced Disappearance, when they had a decision or a view not executed and clearly negated. These three made us to the decision to start the Turkey Tribunal. When we say, yes, the next slide, please. When we say we, that means the organizing committee is, consists of Professor Vande Lanotte, rector of the Ghent University, Professor Powers from the VUB Brussels University, Professor Bossuit, who was former president of the Constitutional Court of Belgium and former president of the United Nations HR Commission for 2 years, Jan de Bok, our former head of Belgian diplomacy, and Christine Mesche, who is lawyer at the office where I'm working now, specialized in sexual abuse cases. So all 5 persons who are quite independent and high-ranked persons in the Belgian society. The next slide, please. Of course, such a tribunal depends largely on the quality and the independence of the judges. We had 6 judges. President of the tribunal was Professor Françoise Tulkens, former vice president of the European Court of Human Rights. Professor Marine Verny, former judge of the European Court, but also former member of the Venice Commission. Professor Lady Bianco, also at the European Court and Venice Commission, was former member. Adjunct Professor Angelita Byens from the Robert Kennedy Human Rights, who was before in the Inter-American Commission, and that's why we asked her, because we wanted someone also from the Inter-American system. Dr. John Pache, former Secretary of the Human Rights Commission, and also professor in Australia, but we took him because of his experience with the UN system. And from Africa, Justice Johan van der Westerhuizen, former judge at the Constitutional Court of South Africa and former professor at the University of Pretoria. Well, he founded actually, I think more than 20 years ago, the Human Rights Center, which is for now probably one of the most important human rights centers in the world. So 6 persons on whose independence and experience and legal expertise, which we found very important, person can doubt about. We prepared, next slide please, we prepared the tribunal with reports that were made public on the website, that were discussed in webinars with quite a huge attendance. Some of the webinars had more than 5,000 people who attended, and who were also communicated timely to the Turkish government with the question to give us a reaction, which we did not get. Reports about torture made by Erik Sotas, who was the former Secretary General of the World Association Against Torture, and myself. Abductions, Johan Heijmans, who's a lawyer who worked indeed on abductions and who used the report of Ankara Bar Association. Press freedom, Philippe Lerut, who is former president of the International Federation of Journalists. Professor Turkut, who is now professor very only recently, but he made his PhD on 1 year ago on impunity in Turkey, and so he's quite expert on that domain. Luca Perilli, former speaker, I do not have to introduce him, with a report that has been endorsed by 2 associations of judges, and a report on crimes against humanity, which I made myself. Being myself, I've been professor in human rights for about 33 years and have some experience in that. Next slide. It was held in Geneva, September 22. Rapporteurs presented a report. We had 15 witnesses. The Turkish government was invited to participate for each topic. We reserved time each time. And the final opinion was pronounced 24 September. What is now the findings of the tribunal? Next slide, please. I will give you very shortly. We have here, for the people present and for those not present, you can get it. We have the opinion of the Turkish Tribunal in a practical leaflet of 64 pages. Everything is in it. It's here. We also have the reports published in a book that's a little bit less practical because it's a bit more heavy, but everything can be found on the website anyhow. What is the finding on torture? Two important findings. First of all, systematic and organized use of torture, and the words systematic and organized are very important, we will see. And secondly, we had a declaration of Mrs. Keskin, who's a lawyer, a human rights lawyer, who said independent medical reports regarding torture are not accepted, and the tribunal said this statement is consistent with the information that has been presented to the tribunal. Very important, you not only have torture, but also the absence of proof that you can deliver by independent doctors. Next page, next slide, sorry, is about abductions, yes. A very simple and short citation. Abductions are a part of state action toward perceived political opponents. First element, we have documented around 100 persons who were abducted, and complaints and allegations of abductions are not properly investigated. As far as these 100 persons abducted, our methodology was that at least 3 persons, independently from each other, had to confirm that they were abducted, that this situation happened. Next slide, please. Press freedom. The findings of the tribunal, you see, are quite long. However, the conclusion is that the extensive and historic case law of the European Court of Human Rights on violations of Article 10 by Turkey, as mentioned in the report and illustrated in the report with new violations, is a testament to the seriousness and widespread nature of the challenges to freedom of expression, including freedom of the press in the country. That also has been stated by former speakers. Judicial independence is the next slide. This next slide, is about impunity, excuse. Because I think that if we judge the situation in Turkey, the impunity issue probably is the most important one. Violation of human rights can appear everywhere. But when there is no possibility to sanction, they, by nature, will develop in a tremendous way. And it's clear, based on the reports and the documentation testimony, the culture of, they call it the culture of impunity in Turkey since 1980 has reached unprecedented levels in recent years, particularly since the attempted coup of 2016. Next slide is about independence, and that I will not repeat what Luca has said, with the conclusion that effective access to justice and thus the protection of fundamental human rights in the current state of the judicial system in Turkey is illusory. The words is very hard. Next slide, because perhaps also the most important element, we asked the tribunal if all this asked, and I think one of the former speaking from the Human Rights Association was mentioning it also, and I think this is the most important conclusion. As a result, the tribunal is of the view that these acts of torture and enforced disappearance cannot be viewed as mere isolated occurrences. Rather, in the opinion of the tribunal, they are to be considered as part of the widespread and systematic attack against the civilian population, and so, I resume, could amount to crimes against humanity on the condition we have the proof of the knowledge and the guilt of the accused. I must insist that a country with, however, still quite important relations with the European Union, where the fact that crimes against humanity are seen to be done is a very grave conclusion, is a very important conclusion. And that's also the reason why the organizing committee, we decided, and on the question of some victims, we decided to prepare a request for the International Criminal Court, which is an unusual and hard task to do. But we think we need to do it, and we will try to do that in January, February, to introduce a request to the prosecutor for the acts of crimes against humanity by other countries who were helping Turkey and Turkish authorities. Thank you, Mrs. President.
Merci, Monsieur Vande Lanotte.
Thank you very much indeed, Mr. Vande Lanotte. I'd now give the floor to Sergey Lagodinsky on behalf of the European Parliament's delegation, the Joint Parliamentary Delegation, EU-Turkey. You have the floor.
Thank you so much, Chair, and thank you for your initiative. I consider this meeting also as an associated delegation. I consider this meeting not to be about any particular initiative or particular project, but a discussion, an in-depth discussion about the situation in Turkey. I'm happy to have heard all the experts as such and not as representatives of any particular project. Yet the picture is clear, and the picture is very dissatisfying and, quite frankly, quite tragic. The delegation of the EU-Turkey JPC, we keep a close eye on what's going on, and we see this as a European issue. And this is probably one of the main points that we should discuss. We know the facts, and thank you for additional facts that we've been hearing today. It's very impressive and very tragic. But the main issue is whether we should make a legal issue, a European issue, into a sovereignty issue. This is not about sovereignty of a nation state. This is about European issues, and especially on issues of domestic situation of a candidate country, as was already mentioned. So we do continue, follow with interest and comment and criticize with interest the situation also on the domestic front. So there is no difference between domestic and European for a candidate country such as Turkey, which I consider as such. The other two questions, I think, are even more relevant. What is the role for European institutions on that? And I think it is important for us to emphasize that we expect the European Commission and the Council to continue to treat the issue of rule of law and judicial independence in Turkey from three important perspectives. Number one, it has to be an integral part of our agenda, not the positive agenda or not positive agenda. This is our agenda, and an integral part of it is the domestic issue. Number two, this should be our primary issue. This is not an issue which comes last after everything else has been done and said. It's about priority. If we're talking about accession, if we're talking about common European future, in which I believe we should start talking about domestic issue. And yes, this should be an effective part of our agenda. And there, I think we've been missing opportunities again and again to make an effective pressure in the dialogue with our Turkish friends so that we have concrete, specific results and not just comments or being deeply concerned as always. And very briefly, finally, what is the role for European Parliament on that? And I think the role should be threefold, and we're trying to do it also with my dear colleague Nacho Sanchez Amor, the standing rapporteur in Turkey. First of all, keep focus on these issues, highlight those issues, and keep pressure on European institutions to follow through with them, but also, and I think this is important, especially for me as a delegation representative, continue dialogue. A very harsh, very critical dialogue, and I'm happy to hear that you are also planning to engage in this dialogue in Turkey, and I wholeheartedly support the mission plans that you are having. I do hope that we will have bilateral meetings of our delegations very soon. So this dialogue, and an integral part of it, this is my favorite word now in the statement, is also criticism, because only this way we will be able to build a common future. So thank you very much for doing this.
Thank you, Sergey. I give the floor now to Nacho Sanchez Amor, comme rapporteur.
As standing rapporteur for Turkey relations. Thank you very much indeed, Maria. The situation that you've our guests today have described for us is one that we're very familiar with here in the European Parliament, all those of us who are familiar with the situation of Turkey in any case. Now, the situations and problems that have been described have also been described in our own Parliament reports on Turkey. Now, of course, we're not acting as a court. We are a political body. Let's be clear about that. Sadly, we see the situation that's been described on a daily basis in Turkey. It's an ongoing situation. It started a long time ago before the coup, and that situation worsened with the coup, and the response was disproportionate, probably pushed by an agenda that was behind all of these changes that we were able to observe. And so this was has really dismantled the judiciary, which lacks independence. And that's why we have the cases of Kavala and Demirtas at the Court of Human Rights. But we should be talking about the hundreds of cases, really. There are hundreds of such cases. Now, we know that this particular case is further advanced in the process of analysis at the court. Now, I've said many times we don't want any more plans or programs. We want to see these reforms carried out and implemented. Now, if someone tweets that they've got a problem with so-and-so, then, we don't want documents, we don't want words. If someone publishes a leaflet, a pamphlet, they face physical threats to their physical integrity. So that clearly cannot be in line with our values, the values we defend. So what can the European Union do? Well, we can act together, be united, and understand that there is, now saying that Turkey has a key role to play with regard to relations with third countries, that's not the right approach. Now, we can't say that Turkey is the United States. Turkey is not New Zealand. Turkey is in a very specific situation. It's a candidate country. And that's why we have a special interest in the rule of law situation in the country. So we can't lump Turkey together with other third countries in this way. We are perfectly legitimate in making these critical remarks, and these cases really represent obstacles to moving forward with our joint agenda. Now, offering a positive agenda was conditional on democracy. Now, but the Council made that offer without any clear, hard and fast commitments on the Turkish side. Now then, the Parliament has taken a very tough stance since then. It's been very sensible as well, very cautious and reasoned in its approach. Yes, we defend European values here. Council does too. Now, this Parliament will shout and cry out, and this idea of Council then sitting back and carrying out realpolitik. Now, that's very problematic. We all represent European values. We must all represent those together. So I would say to my colleagues, if we put together a very critical and honest report on Turkey, then we will be doing our jobs. But I must say this year's report should be quite different to other years. It's not simply enough to say there are problems in the judiciary. We have to take a precise approach to this and really pinpoint where the problem lies. So anyone, all the colleagues working on Turkey, we have to be very, very targeted, precise in the critical remarks that we make. Simply repeating the comments, the general comments that we've had in the past, well, many have said this, it's not going to achieve anything. It won't really improve the situation on the ground.
Nacho, je donne maintenant la parole à Peter Van.
Thank you, Nacho. Now, Peter Van Dalen for the EPP Group, please.
Thank you very much, Madam Chair. What have we heard this afternoon? We have heard that there is no trias politica in Erdogan's Turkey. The judiciary is not independent, at least not independent since the year 2013. The rule of law does not exist in Turkey. More than 60 journalists are in jail. And with that, Turkey is on top with China on the countries around our planet who have journalists in jail. More than 600 people in jail are ill and not treated very well. And hundreds of judges, prosecutors, members of the State Council are even for many years in jail. And some of them died. So there is a gross violation of human rights in Turkey. Last week I had a meeting with Andrew Branson. He was an American pastor. He lived for 23 years in Turkey. And suddenly he was taken in 2016 to prison. He was accused of espionage. And after the international pressure, after 2 dark years, he was released. But even today, he still has nightmares. He cannot sleep 6 out of 7 nights every week. So that is what we see. A Turkey that has no rule of law is violating all human rights. And it is blackmailing Europe, because when we threaten to do something, Turkey will release all the refugees and bring Europe into problem. So what should the EU do? We are talking and talking and talking. We are more specifying all the cases we know. We are more specifying on all the people we have spoken to. I have spoken to many people, you have. We know all that Turkey is an evil state. And therefore, I think it's time to stop talking. We should boycott this country. We should boycott the Erdogan regime and the clique around Erdogan. We should block their bank accounts. We should stop combined sport events with them, like football. And I'm glad to hear that we should bring them before the International Criminal Court. So let's face this. We need solidarity with all the people who suffer every day in Turkey. And for me, no accession of Turkey to the EU. There is no dialogue anymore possible. To talk with a regime that is deliberately deaf is impossible. So my question would be to Mr. Vande Lanotte, what would you propose? Do we need to go on talking? There is no possibility for talking. What do you suggest? For me, it's time to quit. We have talked enough. Many years of infringements of the Erdogan regime by essential laws we all have. Thank you.
Merci, Monsieur Van Dalen. Je donne la parole à...
Thank you, Mr. Van Dalen. Mr. Mavrides now for the S&D Group.
Thank you, Marie Arena. I will be quite short. I will pose 2 questions. One, it might sound like a political question and not so much a legal question, but it is both. Is today's regime in Turkey a democracy, a democratic one? I think that we should decide on that. And once we decide on that, then we have to face up to the realities, the political repercussions of that, which I'm afraid many people around us, they are not ready to accept that. And my second question is this. Taking in consideration that the voting base for Erdogan himself has been middle and low class people, or middle and low class income people, then I think that imposing any economic sanctions would not only be a punish for Erdogan, but it would be also, in a dynamic way, a push for any democratic forces within Turkey, and fortunately enough, there are quite democratic forces, to overthrow this dictatorship that we all know about, and some of us dare to say it. Thank you.
Guetta.
Oui, je crois que tout ce que nous...
Yes. Well, I think that everything we've heard since the start of our meeting requires us to ask a question for which I have no answer myself, or not at the moment anyway. It's something that we're all thinking about, I think. I mean, the question is, should we or should we not continue accession negotiations with Turkey? And Turkey is what it is, i.e. everything but a democracy, and obviously it's a dictatorship that doesn't respect any of the standards which are required for the rule of law. So given that, perhaps we should interrupt negotiations. Now, were we to continue discussions, we would have to do that by being aware of the fact that Mr. Erdogan is not going to live forever, and that these constant violations of all democratic standards that he's opposed on his unfortunate compatriots won't go on forever either. And for example, tomorrow we could see the process of democratization resume in Turkey, i.e. the process that we've seen taking place before the last 7, 8, 9, 10 years. And so if we think along those lines, it would probably be counterproductive to deprive ourselves of the means that we have of putting pressure on Turkey, i.e. enlargement discussions, accession discussions, because as our colleagues Mr. Lagodinsky and Mr. Sanchez Amor recalled, as long as these accession negotiations continue, well, that means that everything that happens in Turkey is something that we have a right to look into, and that gives us a way of putting pressure on Turkey. But on the other hand, of course, continuing these accession discussions is a bit humiliating, really, for the European Union, and also goes against all our principles. I mean, could we really imagine discussing, for example, Egypt's accession under Marshal Sisi, where a country where torture is undertaken even more systematically than it is in Turkey? Well, of course we couldn't. So I would say that in conclusion, I think, I mean, breaking off accession talks would mean that we would deprive ourselves of a means of putting pressure on Turkey, however slight. And secondly, we would also make it difficult for Turkey to come back to its democratization process, which is something that I would like to see. So, colleagues, quite honestly, I don't know the answer to the question, and I'll leave it there. Thank you. Thank you, Bernard. Before giving the floor to the External Action Service, I'd like to ask a couple of questions of our speakers as well. Firstly, as Luca said, until 2010, the accession process showed that it was possible to introduce reforms into the Turkish system. I think now we're seeing Turkey move backwards on all of that. So, in line with Bernard's question, I suppose, how do we see things during the post-2022 period? How can we work with a view to reforms that would be necessary in Turkey in the accession process, and what kind of procedure should be on the table with regard to reforms so that we could prepare an eventual return of Turkey to a process of democratic reform? And the second question relates to the work done by the court. it's called a court, but it's actually symbolic in nature. And this is a court that is particularly under attack. And it's criticized for being partisan. It's attacked by the pro-Gulen faction in Turkey. And could you explain how the work that you've done with regard to the courts covers Turkish society as a whole, rather than one particular movement? Because were it to be suspected that you're only working for one faction of society, that may well undermine your credibility. I think it's important for us to be able to show that what we do doesn't relate to one single group. And then I have a third question. This is probably more for the External Action Service. There's a lot of talk about accession instruments. And I believe firmly that that's important, because there's a lot of talk of reform there, and there are changes that are required to the Turkish system. But there's another thing that we hear a lot less about, which is the customs union. Here in this House, we tend to believe that we could forget accession, but that we could continue and even boost our customs union with Turkey. And I think that's a point of view that's business-like in nature, i.e. let's continue to do business with Turkey in our and Turkey's interests. But there, the European Union has no lever in terms of human rights. So doing that would mean that we would lose any possibility of negotiating on human rights and the rule of law in Turkey. So I'd like to know what the External Action Service's view would be on that hypothesis, i.e. no longer working on accession, but working more on the economic side and economic relations between the EU and Turkey, which would weaken, as Mr. Mavrides says, any leverage we have on human rights vis-à-vis Turkey. So let me give the floor to the External Action Service now. Thomas Frelesen, Head of Unit for Turkey, and then Bernard Brunet, Head of Unit for Turkey. Please. Thomas Frelesen.
Chair, honourable members, thank you very much for inviting us to this important discussion here today on a subject which is indeed one of the most difficult ones in EU-Turkey relations, and I would also like to thank previous speakers. As a candidate country, Turkey needs to uphold and promote values that are included in the Copenhagen criteria. The EU closely monitors all these developments, both here in Brussels and through our delegation in Ankara. However, as indicated also in the most recent Turkey report prepared by the European Commission, Turkey has continued to move away from these common EU values, including those in the judicial system. Cases such as Kavala and Demirtas are the most visible ones, but as was stressed earlier by others also, they are far from the only ones. There are many, many other cases. The EU has highlighted this at the highest levels, recently also in the European Council conclusions of June earlier this year on Turkey, which underlined that the rule of law and fundamental rights remain a key concern. And European leaders have insisted that dialogue with Turkey in this area continues and remains an integral part of EU-Turkey relations. EU officials engage with Turkish authorities on these issues regularly, and furthermore, of course, our delegation in Ankara is actively involved in regularly monitoring trials and works very closely with the embassies of EU member states on the ground in this area also. Now on Kavala, as has been said already, he has been held in prison without having been convicted of any crime, and despite the binding judgment of the European Court of Human Rights in 2019, 6 decisions and an interim resolution by the Committee of Ministers of the Council of Europe calling for his immediate release. This is highly regrettable, to say the least. We are in close contact with the Council of Europe on an ongoing basis, and you are aware also of how serious the issue is for the Council of Europe and the intention to look at initiating infringement procedures if Kavala is not released. The EU has spoken out regularly on this, and it is indeed important to speak out on this. We issued a statement just last month. We have done so in the past and will also continue to do so. We strongly urge Turkey to follow up on the Council of Europe's recommendations regarding strengthening the rule of law, democracy and fundamental rights, and to implement the European Court of Human Rights judgment that calls for Mr. Kavala's immediate release as a matter of urgency and also ahead of the next session of the Committee of Ministers of the Council of Europe. Turkey, as a candidate country and member of the Council of Europe, is bound by upholding the rulings and standards it has voluntarily signed up to for the benefit of all of its citizens. Just briefly in conclusion, Chair, also to address the questions that you raised, the tool of the accession process, I think we consider very much the idea of eventually it would be, of course, for member states and the Council to decide to stop the accession process. But our sense is that you would, in fact, undermine the pro-European forces that still are very forceful and strong in Turkey and that look to the EU and Europe for changing the situation in Turkey as it is right now. So we don't see it. We still see the accession framework as a positive thing. And on the customs union modernization issue, this is now in the hands of the Council. You know, the mandate for the European Commission has not been finalized yet. And this is, in the end of the day, a very long-term process. We would expect that if and when the mandate is updated, that it will include a human rights clause, which eventually will give us a bit more leverage in negotiations with Turkey. You know, an eventual modernization will take many years to negotiate beyond the next electoral cycle in Turkey. So it's indeed something we see as a long-term investment by which we can promote reforms in Turkey, not only in business-oriented areas, but more broadly also. Thank you very much.
Thank you. I give the floor to Bernard Brunet.
Merci, Madame la Présidente.
Thank you, Madam Chair.
Turkey remains a candidate country, and although negotiations are de facto at a standstill, the European Commission looks at Turkey as a candidate country and evaluates Turkey along the lines of the European acquis. And in this context, we do indeed need to report and review developments in Turkey regularly, and we have released a month ago a comprehensive report on Turkey's preparation for accession and respect for the European acquis. And it is not a surprise that the conclusion is that for fundamental rights and judiciary, Turkey is at the early stage of preparation. And it has actually been backsliding in terms of both rule of law, judiciary and fundamental rights over many years. And it's clear that from our report that the situation is far from satisfactory. I think I don't want to repeat most of the information that has been already indicated by previous speakers, but I would like to highlight a few items in our report. When it comes to judiciary, I think we have indeed pointed out that there is a systemic lack of independence of the judiciary. It's not a systematic, it's a systemic. So it's a problem of the judiciary system itself. And most of this problem comes from the constitutional changes and amendments that were done a few years ago, which have compromised the effective balance of power and have given the executive power an overarching control over both the judiciary and the legislative branches of power. And this has been translated in unfortunate cases where lower courts of the judiciary do not abide by decision of the Constitutional Court or the Court of Cassation, or more severely by the decision of the European Court of Human Rights. And it has been already mentioned the cases of Mr. Kavala and Mr. Demirtas, which indeed are highly problematic. When it comes to fundamental rights, I think we've seen many repeated gross violations of fundamental freedom, in particular freedom of expression, freedom of assembly, and it has led to many human rights defenders, lawyers, judges, journalists being put in prison or targeted for legitimate political activities, and in particular also, let's say, serious attacks against opposition parties, in particular the HDP party, which has been threatened with the criminalization recently. Now, it is worrying that there are new legislation being prepared to control social media activity and to control the legitimate activities of civil society. What has been done from the European Commission in this context? Well, in addition to raising our voices, and President von der Leyen raised it herself when she was in Ankara in April, and she has continued to raise it, we have taken a number of decisions. We have stopped any new project financed by the EU in the area of judiciary. We have cancelled a number of projects in the area of judiciary. We have also decided to support more forcefully independent civil society. We are contributing about 25 million euro of support to civil society in Turkey directly every year, and directly managed by the European Commission and not by the Turkish government. We have also, as I said earlier, the Council has decided to put a standstill in accession negotiations, and we continue to raise our concerns in the structures created by the association agreement, because, Madam Chair, in addition to having a customs union, we have an association agreement, which is our legal basis, and irrespective of whether or not we would modernize the customs union, and irrespective of whether or not Turkey would remain a candidate country, we would have the association agreement that would allow us to continue to raise our voices and to continue to engage in a dialogue. Of course, we can debate whether this would be effective or whether this would lead to a result, but at least it would continue to give us a forum whereby we could express our concerns, because there are commitments by Turkey in the association agreement. Thank you very much.
Thank you. Merci. Je vais redonner la parole.
Thank you. I'll now give the floor back to our speakers. So I'll begin with Mr. Philippe. Could you respond to what's been said, please?
Madam Chair, just briefly on the question of continuing or not the accession process. Well, this is an issue which is a little bit out of our mandate, but we do continue to press the EU to use any element, any forum for leverage, and to really focus on the actual situation on the ground and not just the promises of reform. We've had recently a justice reform strategy. We've had an action plan on human rights, while the adoption of these documents just showed the discrepancy between what they were proposing and the reality that we saw on the ground for journalists, civil society activists and others. On your question in relation to the customs union, we think that greater economic ties between EU and Turkey would require an independent and predictable judiciary, would require that independent monitors, including media and civil society, are able to monitor the behavior of companies, the behavior of administrations and others. And the reality is that the use of courts by governments to sanction certain businesses or businesses owned by critics, including by closing, confiscating assets, or sometimes replacing boards of companies, should be a major concern for any investment from Europe. And therefore, we do believe that the element of leverage of the EU would be better suited by not starting the talks for the negotiations of the customs union, as long as we see progresses on the ground in relation to the judiciary, media and civil society. We cannot, Turkey's human rights activists, Turkey's independent judges cannot wait several years for the progress of these discussions to see human rights becoming an element of conditionality and leverage. This is now that the EU should find a strategy about how to use the fact that Turkey is interested by a modernization of the customs union to press for changes to be demonstrated now. And it is before those talks are even starting that the EU should expect from Turkey measurable and concrete progresses on those areas. Thank you for your attention.
Thank you, Philippe. I give the floor to Rehsan, Bataray, Saman, if you want to have the floor.
Thank you very much for all the presentations. Well, shall we freeze negotiations, accession talks? Of course, I'm not in a position as a human rights defender to raise comments about whether or not to freeze accession talks. But I can only make remarks on grave violations of human rights. I think the European Union should stand firm on that. Thank you.
Merci. Luca
Thank you, Luca.
Perilli, if you want to have the floor.
Thank you, Ms. Arena. Just two short remarks. The first relates to the whether Turkey is still a democracy. I would try to give a legal consideration on this. So the Treaty on European Union establishes the common values of European Union, which is the respect of rule of law, respect of fundamental rights, and respect of the minority rights. And there is here the big issue of courts. And the negotiations are grounded on legal agreements. So my question to myself is whether, when there is a serious breach of this agreement and there is no intention to respect the fundamental values of the European Union, there is still space for negotiation and discussion or not. This is my question. Second point, how to rebuild trust in the judiciary. First of all, there have been constitutional changes in the constitutional framework, legal changes in the legal framework, and of course, to this respect, is it possible to go back? It is possible to amend back the constitution and to rebuild a proper legal framework. But then there is also the issue of pain and sufferance in the judiciary and in the society. This is a society which is highly polarized. Many judges, thousands of judges, good judges, professional judges have been dismissed. And there are now new 10,000 judges who have been recruited in a non-transparent way, that they have not been trained to be professional. And professionality is part of the individual independence of judges. So is it possible to go back as regards the character of the judiciary nowadays in this situation? And I would like only mention what has happened in many countries when authoritarian regimes failed. In those countries, there have normally been a political willingness to rebuild trust through vetting procedure, to restate people who were sacked, and to see what are the qualities of the people who have been recruited in the meantime. I wonder whether is it possible to have trust and pacification in Turkey without this process. Thank you.
Thank you, Luca. Johan?
Thank you, Mrs. President. I will first answer the question of Mr. Van Dalen, what can we do? First of all, the European has its own instrument, the European Magnitsky Act. I know the European Union doesn't like we call it like that, but this gives you an opportunity. Like, for instance, in cases of clear torture that has not been prosecuted, the persons who did not prosecute, who do not want to examine a case of clear and even sometimes multiple torture, you can apply this act on that. I think that's something the European Union could do. Anyhow, I must say that with the people from the Tribunal and with people in the United States, we are meeting beginning of December in a platform from the United States, Canada, Australia, people from Europe and so on, to make the first applications in the different systems that have a Magnitsky Act. And I heard people saying we have to take care, and I agree that when we touch not the simple people who are living in Turkey, who are victims already by the system and now should be by the sanctions, but this European sanction instrument gives the possibility for the European to really aim and focus on those who you want to aim on. The prosecutor who all the time is putting Kavala in jail again on new and false allegations. Why should not have a sanction on the Magnitsky Act? That's my question. Secondly, we go to the ICC, as I told. Countries could help, of course, because when an individual puts a request, the prosecutor still has a possibility to find it opportune or not. Is it gravity? Is it enough? If one of the European countries supports the request, it has to be examined. But that's, of course, not the European Union. That's the countries. I must here say also that when we will introduce this request, most probably public authorities from Albania, Bulgaria and Moldova will be involved too. It is not only Turkish, and there is one EU country and one country who's candidate, Albania, to enter the European, who are involved too, because they allowed abductions illegally against even judicial orders not to bring the people back to Turkey. And that's, again, not the European Union, but that's the state. There is no state complaint before the European Court. And it was Professor Bossuit, the president of our association, who has been a long career in international institutions, said it is really not possible to understand with all what happens that no European country ever introduced a state complaint against Turkey before the European Court, which symbolically of at least would be very important. So if you ask me what to do, I think that are three possibilities, partly European Union, partly states. Secondly, Madam President, when you said the pluralism, and is this the Turkey Tribunal is organized by the Gülenists? Well, you know, we were in Geneva and we were there in a hotel. Hotel was run by a Belgian lady, by the way. And the ambassador of Turkey went there to say, listen, you should not allow this because this is a terrorist organization. It's the first time, I think, that Mrs. Tulkens, Professor Baroness Tulkens, Vice President of European Court, has been treated as terrorists. When you have nothing to say about the message, you try to say something about the persons. In the witnesses, we have clearly stated all the time, and we succeeded, that all the time, for each topic, we had different people. We had people who were sympathetic with the Gülen movement, people who were sympathetic with the Kurdish movement, and people who simply were critical. And we have been really emphasizing that, and perhaps it's the first time that it happens. And even with Mrs. Oktay, who is a journalist, Kurdish, she said, now we see that people from the Gülen movement are concerned, but they should have done it earlier. So even they were criticizing each other. So we can never say that it's not pluralistic. Of course, you have the capacities of the judges, and on the financing level, that's why we said that it's crowdfunding, and you cannot contribute more than 10,000 euro for one person. So no one could ever decide what we have to do. By the way, the cost was 220,000 euro. We didn't pay judges, we didn't pay rapporteurs or nothing, and we're still missing 40,000. So if everyone wants to contribute, he's welcome, sorry to say. But that the independence of this Turkey tribunal is out of discussion, I think.
Merci beaucoup. Merci pour.
Thank you very much, and thanks to all of you for your contributions. We'll continue to work on the human rights situation in Turkey, and we hope that the Human Rights Subcommittee will be able to visit Turkey in 2022 to continue to make progress with human rights. Thank you very much. We'll now move on to the next point on the agenda, which is an exchange of views on the human rights situation in Burundi. So I would like to thank Carlos Orignon, co-chair of the ACP EU Joint Parliamentary Assembly, for being here with us. It's very important that our subcommittee closely monitors situations in this country, in Burundi, and we are in discussions with members of the Burundian government for the future of our bilateral relationship. I might just hold off for a moment to let people leave who won't be here for Burundi.
Et de l'Afrique de manière plus générale.
Or Africa, more generally speaking.
Pardon. Voilà. Et donc,